You are Mr. Scott Sanders.
Yes.
Mr. Sanders, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 25th, 2025, officers initiated a subject stop at a Walgreens on East Mount Houston Road, Harris County, Texas. Officers observed a defendant sitting outside of the entry holding a brown cardboard sign, panhandling. Officers approached the defendant. Defendant stated, "Okay, I'm leaving. They told me to leave. I'm leaving. Don't take me to jail." Officers asked consent to pat down the defendant. The defendant consented to the pat down. The officers observed a green leafy substance in a plastic bag located on the defendant's person. The defendant stated he forgot the marijuana was there, but that it was only kush. Officers observed an additional plastic bag containing a green leafy substance. The officers observed the marijuana to weigh 0.045 ounces. The complaining witness was identified by their Texas driver's license and advised that the defendant has shoplifted multiple times and has been trespassed. Complaining witness informed the officers that complaining witness asked the defendant to leave prior to the officer's arrival. Complaining witness advised officers that the defendant initially left the property. Complaining was unaware of the defendant's return to the store until the officers contacted him outside the store. Officers note defendant's theft case was against that Walgreens and was dismissed. Officer notes that the defendant has been criminally trespassed from the same Walgreens. Officers also noted that they did observe a meth or crack pipe on the defendant's person. The complainant was able to identify the defendant based on the previous mugshot.
Mr. Sanders, I'm going to find that there's sufficient probable cause to go forward with your case.
Yes,
Let me provide you a lawyer today so that you can talk to someone about this case. All right. For now, do not go back to this Walgreens. Let's not talk about this case because you have the right to remain silent. I don't want you to say something that hurts your case.
I want to say something about seeking treatment.
Okay. Let me get you a lawyer first and then we can talk about it and we'll try to help you as much as we can. Okay. Vic, do you mind?
Yes, Judge.
Okay. I'm going to have you sign a receipt of Victoria and then we'll have you take your seat in the jury box, sir. Okay.
Right this way. Go ahead and sign for your step, please. Next judge is page 32, Williams. Come on up.
Go right to the stuff. Everybody in front of you.
Good morning, Mr. Williams. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000.
Whoa, pause here. Did you catch that? Because of his high blow on the breathalyzer, this isn't just a regular DWI, it's been elevated to a Class A misdemeanor. Translation? More jail time, bigger fines, and a permanent mark on his record. Quick question, do you think the punishment for DWIs should be even harsher, or is this already too much?
$1,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Okay. On March 25th, 2025, an officer was dispatched to Montrose Boulevard for a call for service related to a driving while intoxicated. The officers observed the defendant's motor vehicle upon arrival. The officers observed the defendant's vehicle to have major front end damage, multiple airbags deployed, and to be leaking fluid. The officer met with the witness who called 911. The witness stated he observed the defendant's vehicle to have struck a light pole. The witness stated that he did not see the actual crash, but saw the defendant back up and start driving away from the crash scene. The witness observed the defendant drive several hundred feet before stopping due to the motor vehicle being disabled. The witness stated that they observed, the officer made contact with the defendant, and the officer observed a strong odor of alcoholic beverages emitting from the defendant's person. The officer also observed the defendant had bloodshot eyes and slurred speech. The officer observed the defendant had trouble maintaining balance as well. The defendant consented to standardized field sobriety test. The officer observed 6 out of 6 clues on the HGN test, 7 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. The defendant consented to a breath sample, and which the test readings came back at 0.185 and 0.168.
Any prior DWIs? And then does he have a license?
No prior DWIs, Your Honor, and I'm running that license.
Please. Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail.
His license is eligible. No.
As long as you have a valid license and liability insurance in your name, then you may continue to drive. But if I find that you're using, it's not going to go well, and I will revoke your bond and put you in jail. Do you understand? Do you have the ability to hire a lawyer, sir? Okay, we will give you time to hire a lawyer, so I will first have you go to Victoria, sign a reset. You will then get with Fleischer for your bond conditions. After that, we'll get you out here to hire a lawyer. All right? Please.
This way.
Good morning, Ms. Woods. Ma'am, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 26, 2025, in Harris County, Texas, officer was dispatched to a disturbance call. Officer met with the complaining witness who stated that he and the defendant were in a sexual relationship. Complaining witness stated that he and the defendant got into an argument over the Wi-Fi password. The defendant punched the complaining witness in the face, head, causing pain. The defendant also ripped the complaining witness's shirt, scratching him in the process, also causing pain. Officer observed the defendant to have visible injuries to his face and back.
Do we know whether he wants to have contact?
No, it's not.
He does not want
He
to.
does not.
Okay. Ms. Woods, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. I am ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate this, we will revoke your bond and put you in jail. Do you understand me? Do you have the ability to hire a lawyer? We can have you fill out an application. I'll take a look to see whether you qualify. Deputy Miranda is going to give you an application. I need to know everything about you, where you work, what kind of money you make, money in the bank, car, what kind of car you drive, and then I'll take a look to see whether you qualify. I'll have you sign a receipt. Victoria will give you the application, then we'll have you take your seat in the jury box. Thanks, Mitch.
This way.
And they're dismissing the felony upstairs, and he's doing, yes, for the probation with TRAS conditions.
Has a TRAS been done yet?
Yes, and the recommended IOP SOP.
Salustria.
No, shh. You have, or you're not you, but your lawyers have worked a killer deal for you today. You speak English, right?
Yes, I do.
Where they're going to dismiss the felony in exchange for your plea on this case. I'm going to tell you now, this is not something that happens very often. So get a clue. Do you understand?
Yes.
The agreement that you have worked out here is you're now charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have is 180 days in jail to be probated for 15 months. You need to understand that this charge is going to go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. Not only that, whenever you get pulled over, officers, the first thing they do, and the only thing they do when you get pulled over is they look at your record. If they see that you have a prior DWI, if they see that you have a prior felony PCS, you think they're going to treat you good if they smell anything funky? Probably not. So don't give them the ammo to shoot you with a gun. It is a DWI. Any prior DWIs? So the agreement is a DWI education class, one victim impact panel, a TRAS, but you have already done it. So the TRAS here is recommending intensive outpatient treatment followed by supportive outpatient treatment. This is what you must do. If you fail to complete these conditions, I will issue a warrant for your arrest. I will put you in jail and I'm going to bring you right back out in orange, and we're going to talk about whether you violated, and if you do, you're looking at 180 days in jail. Do you understand?
16.
No drugs, alcohol, random testing, and a guardian and a lock.
He has, we're going to do the portable because he's not driving, doesn't have a license.
You'll be signing an affidavit today promising us you're not going to drive.
Listen closely here. Probation sounds like a get out of jail free card, but it's actually a trap for a lot of defendants. One mistreatment, one failed test, and boom, you're back in orange jumpsuits. What do you think? Are these conditions fair accountability, or just setting people up to fail?
Mr. Garcia, do not drive. If you want to see me grow horns and a tail, I'm telling you, don't drive. If you want to drive, do things the right way, ask for permission, get a license, get insurance, and then I will be dancing happily because you're doing things the right way. But if you go out and you do it on your own and you're not licensed, I'm going to lose it. You understand? All right. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will send it to this agreement. Good luck to you, sir.
Thank you very much, Judge.
Is that all? Judge, we have a,
Mr. Garcia?
no,
All right. Good luck, sir.
on Mr. Sullivan, Mr. Dixon. For Sullivan, there was a PC.
Coach, on Miss Loyola, this is the young lady that a few days ago you took into custody because she picked up a new case while she was out on our bond.
Right, okay.
She had the felony case. The felony's reset. She's here for her, I guess, arraignment on the new bond. But I think you had already modified her bond conditions 2 days ago. So,
Come up, Ms. Loyola.
we do need to talk about some driving issues though, Judge. So
She doesn't have a license. That's the issue. If I remember correctly, right?
I think you do have a license.
I was working on getting it fixed. It was, not a little.
If you don't have a license and liability insurance in your name, don't drive. It's as easy as that. If you get your license, then we can talk. But until that point, I don't care what you have to do. I don't care what baby needs picking up. I don't care. You cannot justify getting into a car and driving unless you have a Texas driver's license and liability insurance in your name.
I was
You-
working on getting it.
Okay, working on it doesn't mean that you get to drive because you're working on it. No driving until you have a license in your possession. If I find that you do, I can have a contempt hearing, and every time you drive hereforth, it's up to 6 months in jail and a $500 fine. If you pick up a fourth case, I'm going to lose it. Do you understand? All I'm asking you to do is follow the law. I'm not asking you to do Pythagorean's theorem. Okay, we'll give you a normal setting. Well, actually, no, we won't. The assault's at nearly 200 days now. Is this your case, Sebastian?
Yes, it is. I just,
Discovery complete?
I believe it is, Judge. I'm trusting.
Judge, the problem is it's the same transaction out of the felony court, out of the felony case. So I've tried to reach out to her felony attorneys. She tells me that it's bad communication with that particular person. So I'll have to try to really hard to find out because she's hoping
Right
that.
here.
Yes.
Mr. Gould, Mr. Gold is here. That's the lawyer.
Yeah, I saw him today.
Did you speak to him? And does he know the?
Yeah.
Okay, so I guess he knows the situation.
I tell you right now, Judge, I just. As far as the assault, the only thing is that there's some CPS records. I still don't know if the case is closed, because obviously they don't give it to us until the case is closed. But apart from that,
I mean, does that really come in this case anyways?
it can. I mean, so typically the things that would be in there is typically they do an interview with defendant, they do an interview with kids.
I mean, unless it's relevant, I don't know, but.
Yeah. I mean, but you are right. I mean, it is a case by case basis.
Can you tell me when that felony's reset to?
The felony is reset to the 21st.
And is there an offer in the felony case?
I believe the note is, I mean, essentially the offer upstairs is that if she takes something on the misdemeanor, then we'll get rid of the felony.
Okay, so they're set for 4/21. I'll give you the same day after the day it's clear trial here.
Gotcha, 421, Judge?
21. Right,
Is there any
I would
way
imagine that's probably a global offer for everything.
Can we go 422?
Sure.
Okay.
But then she'd be coming that day and then the next day. She's on bond.
Right, I got you.
up to you.
But hopefully I'll talk to her. If we can get the deal together, then I might just bring her back before then to get it done.
Okay, but after that setting goes clear trial.
I got you.
Got it. All right, John.
Thank you, Judge.
Leaves you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Has probable cause has already been found on this, right?
Yes, Your Honor. So she, it's already been found, but this case is really old. She didn't come to court. So it was just kind of, she got rearrested for the same charge.
Okay. Where's this from? If you don't mind.
Your Honor, I'm sorry,
Just Neves.
Eames?
N.
Yeah, thank you.
N-I-E.
Your Honor, the offense date was October 11th, 2023.
Where from though? With that one.
Oh, where? I apologize.
Walmart.
It was Walmart, Your Honor.
Hey, can you look to see if discovery is complete?
Yes, Your Honor. It does look to be complete, although we'd have to talk about the videos. Yes.
Well, just to get this case, because they already had a prior PTI offer, which you're supposed to do an anti-theft course. They just reinstated the offers. They said that they'll still take the offer.
Have they said that they're going to keep the offer?
I spoke to them this morning.
Okay.
So she's going to complete this class this week, and I'm going to send it to them for dismissal.
Okay, this case is 1,269 days old. I'm now putting a monitor on your ankle so I know where you are at all times. You have 2 weeks to get this class done. If you don't, I'm going to set your case for trial. Do you understand? You get no more resets after that.
Okay.
Okay, all right.
Thank you, Your Honor.
So Felicia, if she can get today, please. You are Mr. Vasquez Lechado.
Yes.
Sir, you're charged with driving while intoxicated, facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 21 days in jail with credit for the 7 days that you have done. You're pleading guilty to this offense and it is now going on your record. You need to understand that from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. If you ever get pulled over from now on, officers will look at your record, they'll see a prior DWI. If they smell alcohol or dope on you, it's probably not going to go well. So from now on, I would never, even if you have a sip of alcohol, don't get into a car and drive. It's probably not going to go well for you. You're giving up a lot of rights by entering into this agreement. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it goes on your record. It'll be there forever. Is this what you want to do?
Yes.
You plead to the offense, guilty or not guilty?
Guilty?
I'm going to find you guilty. I will follow the agreement, send you to it. I'm now going to suspend your ability to get a driver's license for 90 days. Do not drive until you get a license. And good luck to you, sir. Thank you, Mr. Moore.
And Your Honor, if I may
Sorry,
mention, I did want to mention something else, Your Honor. This was a case that I was appointed to maybe like 2 days ago. I did speak to Mr. Vasquez to let him know that not all the evidence is in and that he does have the right to that. He has been in custody since January when we got transferred to ICE, which he says he no longer.
So-
wants to be for the other case.
You need to understand that not all the evidence is in this case. By getting all the evidence, it's very possible that she may have a chance to fight your case and beat it. Once you plead guilty, there's no turning around. You cannot come back and return this like you don't like it from Target. Do you understand? Do you want more time to fight the case or do you want to continue with this plea?
I'm fine like this.
Okay. All right, I'll make a documentation that
Thank you, Your Honor. I appreciate that.
it's against your.
Yes, Your Honor.
All right, come on up.
How you doing? Hey, Judge, good morning. This is Mr. Dalen Calhoun, Judge.
Let me sign this real quick.
Don't say anything about the case, okay?
Oh, that's.
Use the focus of this.
Getting.
Yeah, it's to the proper place to handle your business.
Thank you.
Who?
That's right. That's right. I'm so confused.
Scott Sanders?
Okay,
Okay, now this one's wild. We've got stolen cars, state lines crossed, and even surveillance video evidence. But here's the kicker, how do we prove the passengers knew it was stolen? That's the big legal debate, guilt by association. Isn't always enough. Tell me, should everyone in that car face charges, or just the driver?
what is his name?
His name is Jalen Calhoun.
Good morning, Mr. Calhoun.
Good morning, what you doing?
So it seems that you are one of 4 co-defendants that we have on a case arising out of another state.
Yes, sir.
You're wanted out of,
Louisiana, Natchitoches Parish. I butchered the pronunciation, but.
Natchitoches.
Yes,
What is it?
Natchitoches.
That.
Louisiana.
Lawyer is asking me to set you a bond, but I don't know. I don't know you. I've never met you before, and I have a very short amount of time to get to know you to see what kind of person you are.
Right.
Paper really tells me who you are. The words coming out of your mouth, I just, right. So tell us about Mr. Calhoun.
Your Honor, he's wanted out of Louisiana for transfer and possession of stolen vehicles, or equivalent to theft of a motor vehicle, and him and 3 other individuals, one whom is charged with UUMV, were found same day where they stole a vehicle, and we have a parallel charge with Louisiana where they're charging him for the theft, and we have for the driver.
But the thing about it is, I wasn't there.
Don't you really think that you can just start spitting out something? Or where do you think you are? Really?
My bad.
You think that this is helping you, Mr. Calhoun?
Sir.
You're not at home. You're not on the street. Okay. Please.
Your Honor, the same day that they stole the vehicle, which was captured on surveillance off campus, they transversed state lines and came to Texas, and they were found in Harris County with obviously traffic infraction being the probable cause, and found with all 4 occupants of the vehicle. The fact that they transversed state lines, they would be opposed to a bond. There was also, and because I took the charge, I know before the office reports out, is that there was also a firearm found on one of the passengers and that they were trying to conceal. At the time, the officers were getting everybody removed from the vehicle, and obviously 2 of them being under the age of 21. So they would be opposed to a bond for.
So hold on a second.
Yes, Judge.
It's a stolen car.
Yes, Judge.
Out of Louisiana.
Yes, Judge.
They come to Houston.
Yes.
All 4 of them.
Yes.
How do we know the other ones knew that it was stolen? Do we have any kind of?
In Louisiana, and they did it in real time. And the complainant stated none of the occupants in the vehicle had permission to take the vehicle.
I know that.
Oh,
But how do we know that they knew that it was stolen? Right? So what if I come pick you up in my car?
Oh,
It's
I
a
see
stolen
what you're
car. You have
saying.
no idea it's stolen.
I see.
Like if everything's ripped off in the inside, you got like, there's a screwdriver for the steering wheel and the steering column's been ripped off. Then there's facts that lead you to believe that it's a stolen car.
So for running the plate because it was reported stolen, and the fact that it was, well, at the time of the, I'm sorry?
That's still,
No, again, on surveillance video in Louisiana, that they have it in Louisiana, that these are the original individuals that stole the vehicle. That's how they knew, that's how the officers in Harris and the officers in Louisiana knew that they knew it was stolen because they were the ones who stole it.
they have them, you saying on video?
Yes, that's what
All
I'm
4
trying to,
together is taken?
yes, that's what I'm
Yeah,
trying
well,
to.
that's something.
Can we see this video? I haven't seen this video. It's
You're not gonna get to see the video. That's with the
That's in
underlying criminal
Louisiana.
case.
Well, you're basing your decision on a video that the prosecution that says he saw, you haven't seen, I haven't seen.
I just want to know how they impute the thievery to him.
Correct.
And he's saying that there's a
it's because of a
video.
surveillance video.
And the Louisiana officers were telling the Harris County deputies that they have it on surveillance video. That's how.
Specifically what? Where was my client? Was he the one?
We're not gonna get all that.
Right, but we're talking about that.
Our criminal history?
No, Your Honor. This is based on flight risk. They literally transverse lines the same day they stole a car.
It hasn't been proven that he knew it was stolen.
How many got charged with the UUMV?
The driver, because that was the only
That's the only one.
driver, right?
So your position on bond is what?
There's no bond because of the flight risk. They literally fled the same day within 24 hours, really 24 hours within stealing a car. Judge. They literally fled the state.
They keep
stealing a car.
saying they stole the car. He didn't get charged with stealing the car. He's not in the vehicle. He is charged with transfer.
No.
He
He is charged,
he is being
but in
charged.
Louisiana.
Well, then that's a,
He is charged, but in Louisiana.
Okay, well, he's
Here,
being charged with
just being
that.
charged
Just
with
because
it.
he's charged with it doesn't mean you're going to convict him. I see like very good arguments as to why he shouldn't be convicted. Secondly, if we're talking about flight risk, he was a passenger. He hasn't had the opportunity. Where was he going? Did he know he was fleeing the jurisdiction? He doesn't know that it's stolen. Like you said, is the steering column broken? Okay, at that point, perfect. He should have known. There's nothing to say that that's what happened in this case. We're assuming the worst. Let's assume the best. He's presumed innocent. Let's not assume that he knew he was committing a crime. Let's presume he was innocent. So in that case, let's give him a bond. Let's allow him to go and fight this case. He can't fight it here. He's fighting an allegation that we don't have, the surveillance video that we haven't seen. Let him go fight the case over there.
21, sir.
I still stand on no bond.
I mean, I'm
Regarding the flight risk, and so.
Well, you got to understand, in life, there are consequences to action, right? When you hang out with dogs, you get fleas. I can set you a bond, but you need to understand from the time that you're released, we give you 2 weeks from the date of that release to go turn yourself in to that parish in Louisiana. If you fail to do that, I will revoke the bond that I'm going to set here. I'll set it at 0. I will not give you another one. You can't run forever. At some point, we'll get you. And then that time, when we do get you, I will physically hold you until Louisiana comes and gets you. Do you understand?
So if I go down there, I'm at the bond down there 2 months.
That's correct.
Right. The thing is that I will probably set a bond around $5,000. You'll probably have to make all of it because you are a flight risk. You're wanted out of another state. If you waived yesterday, we have buses coming in and out of Louisiana about 2 times a week. So if you keep the waiver, you'll probably be back Wednesday. At the latest, Monday, you'll be back in Louisiana, Monday-ish. Where if you want to bond out, you can, but you're going to have to make it on your own to Louisiana. And then you'll have to bond out. Or no, you're going to have to turn yourself in over there. You can't bond out. Is there no bond set?
I believe it's no bond. I'll double check.
You'll have to turn yourself in there. So if you want me to set a bond, you have to withdraw your waiver and you're going to lose the credit that you've built up toward them. Because if Louisiana doesn't come get you here within 14 days, we release you regardless. And then you don't pay anything. You're going to get released. So I'll let you talk with Ricardo and make the decision what you want to do.
Yes, sir.
What amount would you be thinking, Judge?
5,000.
5,000? Judge, he is 21 years old.
Yes, sir.
He would be seeking the support of his parents. It would be a bond that he's got to post 100% on. Would you consider going to 2,500? No? Okay, fair enough. I'll talk to my
Lucky to
client.
even get a bond, Mr. Calhoun, really. And I don't even know if I'm going to do the other ones as well, I mean, I don't know. So.
I'll talk to my client.